Hi, I'm Phil Ashey from the American Anglican Council, here in my capacity as chair of the Governance Task Force of the Anglican Church in North America. And it's that time of the year, again, when we present to you, the whole church, all of the proposed amendments to our Constitution and canons that we want you to vote on through your representatives to Provincial Council 2023 meeting in June. Now, we're standing right here in the sanctuary of a brand new church, St. Simon's Anglican, here in the Diocese of the Carolinas. And you may be wondering why I'm bringing that up. And that's because this young church plant has grown to about 40 adults and about 10 kids in just over a year, meeting in leased space. And this is an important visual reminder of us that the canon law, the amendments, all of the processes we're going through are a means and not just an end in themselves. They are a means for us to do the mission that our Constitution calls us to in Article 3, to share the transforming love of Jesus Christ to all of North America. And we want to do that in a way that honors God. That has integrity and gospel truth to it. That's what canon law is all about. Now, you'll know from our past experiences in doing this that we have several phases, and we're doing the first phase. And phase one is where we present to you these proposed changes for comment by the whole church. So the Governance Task Force met by Zoom in January and then in person just a few weeks ago, and then reported this work to the Executive Committee meeting February 28th up in Luther, Maryland for their comments. So we've already had quite a bit of discussion about this, and now, since what touches all must be decided by all, as we've discussed and mentioned in previous presentations, now we want the whole church to weigh in on what we've done. So I'm going to walk through these changes with you, and you're going to see them on the video screen that you're looking at. And then I'm going to be sure before we close, when we talk about questions and the response, that you have my email so that you can send in questions and comments and suggestions. So the very first thing that we did is look at a piece of old business from Provincial Council 2022 at the Falls Church. Someone raised the question, when we use the term days in our canons, what does that mean? Is it just weekdays? Is it weekends? Is it business days? What is it? So we have added the following to our definitions. Days. The term days shall refer to calendar days. So that's just for your information as a definition in Title I. The next big change is actually not a proposed amendment yet, but rather a motion. And this has to do with the whole issue of how do we respond to accusations of sexual misconduct against clergy and lay leaders alike. How do we respond to allegations of the abuse of ecclesiastical power? What do we do about spiritual abuse? And this raises a lot of difficult and challenging questions. I want you to know that the Governance Task Force has a Title IV revision committee that has been working with the ACNA Task Force on Adult Sexual Misconduct, because we want to look at this in a global sense. How do we look at the way that we handle accusations? How do we help people become better disciples of Jesus? Because that's really the purpose of church discipline as opposed to secular discipline. How do we provide immediate, meaningful, appropriate pastoral care to those who have suffered? And how do we ascertain the facts, the underlying facts of an offense, as well as honor the feelings and the trauma that victims and survivors have experienced. We realize that because we are dealing both with church discipline of clergy, which is what Title IV is all about, but also cases where the actual misconduct may be by a lay person, a lay catechist, a Sunday school teacher, or some other lay leader, that they're not going to fall under Title IV because that refers only to clergy. So we're going to do this. We came up with a motion anchored in Title I, Canon 5 of Dioceses. And here is our motion: to present at Provincial Council 2023 a proposal anchored in Title I, Canon 5 of Dioceses of processes and mechanisms to receive and respond to allegations of misconduct with certain minimum requirements for dioceses that may include an officer appointed to receive allegations, as well as a team of persons designated to respond to allegations, including an advisor or other person designated by the bishop to advise the complainant about the relevant processes and mechanisms, and to make sure that appropriate pastoral care is provided. The diocese is responsible to make its process public. Wardens and clergy are responsible to report all allegations of clergy misconduct to the bishop. If at any point there is reasonable cause to believe an offense has been committed under Title IV, Canon 2, that's the list of offenses for which clergy, deacons, presbyters, and bishops can be placed under discipline, it shall be referred to the disciplinary processes under Title IV. Such proposals are to be presented by the Governance Task Force to Provincial Council 2023 for initial response and review, with a view towards final canonical amendments being drafted by January 2024. Now, let me unpack that. It's a big thing. This is what we've been focused on in the life of our province. How do we walk in the light? How do we do justice and love mercy and walk humbly with our God? How do we maintain integrity of our mission to bring the transforming love of Jesus Christ when our own leaders are engaged in conduct that is unbecoming? So this resolution was approved unanimously by the Governance Task Force. So we're not asking you to vote on the resolution. What we're asking you to do is consider the language of this. We will have a subgroup that you can send suggestions to on these points. Are these diocesan minimums that we are proposing, are they enough? Have we missed anything? What else should we consider? We've already, it's already been brought to our attention, yet this is good about once an accusation has been made, what about prevention? Should dioceses also be required to publish their adult and child sexual misconduct prevention processes as well? What do we need to do in Title IV once we've done these diocesan minimums? Because frankly, the diocese is the place where this needs to be dealt with. And different dioceses are doing different things. C4SO, Christ Our Hope, the Gulf Atlantic Diocese have observed these minimums already, from which we have taken some guidance. But they're different processes that they've come up with. We're not saying one size fits all. What we're saying instead is, dioceses, you need to devise a process that has these minimums to adequately protect the flock and make sure that misconduct by either lay people or clergy doesn't take place. And if you are a diocese that's so small and under-resourced that you just can't imagine even doing this, here's the thing you need to realize. You have to do this. And if it means partnering and putting yourself under another diocese's processes and mechanisms, then so be it. because this is something all dioceses have to do. It's that important. It's that critical for maintaining the integrity of our witness of Christ's love. The next change is in Title I, Canon 6, Section 8, concerning annual reports, to include canonical changes. So here's the deal. I mean, right now, since we've been formed, dioceses can go ahead and amend their constitution and canons, and the province doesn't tell them what to do or not to do. It can't do that as a matter of subsidiarity. But what happens when a diocese canons either fall out of the boundaries, the healthy boundaries the provincial constitution and canons provide, or they actually enact something that is contrary to the constitution and canons of the Anglican Church in North America? So in the annual reports that congregations have to make, with the approval of their diocese and the help of their diocese on or before March 1, we've added this important language, and that is, on or before March 1 of each year, the bishop shall ensure that the diocese forwards to the executive committee any changes to the diocesan constitution and canons since its last report. Now, what that does is it gives us the ability to see what changes have been made. We have no authority to tell the diocese to change it or to wordsmith that. But if there's a problem, we can get back to the diocese and say, hey, this is a problem. Have you considered this? Maybe you might want to make some changes. And that, again, provides a certain continuity and uniformity of holiness and good governance within the Anglican Church in North America. Now, we had another change that we proposed in Title III, Canon 2, Section 1, concerning the general requirements of those to be ordained. It was something that I have been talking about, and others, about adopting uniform codes of clergy conduct in each diocese that spell out what spiritual abuse is, or pastoral abuse, or sexual misconduct. And we thought that this language might be appropriate. A diocese may require candidates for ordination to meet additional standards not inconsistent with this canon. Ultimately, we withdrew this language on our own motion because we realize bishops have an inherent right as the superintendents of those being ordained to say to an ordinand or to all of the clergy in the diocese, hey, faithfulness and service, the uniform code of clergy conduct that comes out of the Anglican Diocese of Sydney, Archdiocese of Sydney, and has been adopted by the GAFCON Anglican Network in Europe, that this is something that everybody should sign on to. A bishop could say to his clergy and to those in the ordination process, I want you to sign this. And this would be a customary or a document that everyone would have to sign. It could be updated every year. And we commend that as a possible best practice for dioceses, but there's no need to put this actually in the canons because bishops have the inherent power of their office to require that. Moving on to Title IV on church discipline. Let me just again remind you of the Lloyd Jacobs report. I think it was 1947 or 1948. This is the Archbishop of Canterbury and York's response to the revision of ecclesiastical discipline in the Church of England. And they made this very important point, and that is that discipline comes from the same root word, disciple. And so unlike criminal discipline, which is to punish and possibly rehabilitate and isolate, or civil discipline, which is to get people to make restitution or pay enormous fines for damage that they've done, the purpose of church discipline is unique. It is to make better disciples of everyone in the process, better disciples of accused, clergy, presbyters and deacons and bishops, better disciples of the bishops who are supervising the disciplinary process, better disciples of the chancellors and canonical investigators and trauma care counselors and advisors, better disciples of the accusers and those who have been wounded. That's the purpose. It is unique. And I want us to remember that as we go through and make these continuing revisions of our Title IV ecclesiastical disciplinary canons. One of the things that's come up is this particular section concerning charges under Title IV, Canon 2, Section 2, Sub 10, habitual neglect of the duties of the charged or accused member of the clergy's office. And the question that's come up of late is, what does habitual neglect actually mean? Is it more than one offense? Is it 2 or 3? Does habitual mean it has to be within a confined or specific period of time or over a span of years? And we wrestled with the possibility of changing in a word in exchange for habitual, but realized that this old and sometimes even archaic language has a whole history of it that we can actually research and understand. But at the same time, habitual is not just a neglect that is repeated, it has to have an impact. And so we have changed that now to read that this offense is grave or habitual neglect of the duties. And we feel that provides a much more measurable offense that can be put in a presentment. The next section of Title IV that we looked at was concerning requirements for presentment of a bishop, and specifically of notice to a bishop. And so we are adding this language because we realize that when a presentment, either by 3 bishops or by a certain number of lay people, including presbyters, deacons, and lay people, if it goes in the latter way and they make a presentment and they send it to all of the bishops in the College of Bishops of ACNA, number one, the college doesn't have a mechanism by which it deals with that and can make a presentment. It ultimately has to go to the archbishop. And you don't want, the college is going to have to be in the case of a presentment of a bishop or an accusation against a bishop, is going to have to be the ones that pronounce the sentence. And so we are eliminating the College of Bishops as a recipient of the charges in writing, so that it shall be presented to the archbishop or the archbishop's delegate. The grounds of accusation must be set forth with reasonable certainty of time, place, and circumstance. The charges shall promptly be referred to a board of inquiry, and when such referral is made, the archbishop or his delegate shall inform the presented bishop of the nature of the charges and the sections under Title IV, Canon 2, with which he has been charged, period. Now, why do we do that? Why do we give him notice? Well, in an analogous situation, in a grand jury, where you've got a high-profile leader or person accused with a misdemeanor or a felony, and you're trying to go the extra mile, there's always notice of some kind given to the accused. And in the model ABA rule on boards of inquiry, not only do the prosecutors have an affirmative burden to present evidence of the innocence of the accused to the grand jury, but also the accused person can actually testify before the grand jury if they waive immunity. Well, we don't provide that, any of that, and that kind of notice, and we have to ask ourselves, why are we not providing even the minimum due process that would be afforded to this person if they were facing secular processes? There has to be a good theological reason. And so what we've come up with is that when it's referred to the Board of Inquiry, at that point the bishop should be notified, because that's a very serious point in the process where the evidence is being examined by a board of inquiry to determine whether there's reasonable cause to proceed with the presentment. And at that point, if we're going to give the bishop an opportunity to search his heart and his conscience and make whatever amendments need to be made in his soul, in his heart, in his thinking, in his acting, in what he has contributed to this, he at least needs to know what they're looking at. So we don't include the names of the people that are making the presentment, but we do include the grounds of the charges and the particular offenses under Title IV, Canon 2. Now, moving on to Section 3 of that, concerning the Board of Inquiry, most boards of inquiry are going to include someone from a diocesan ecclesiastical trial court, presbyters, lay people. It may even include a bishop or two. But here's the thing. It's not a guarantee that there will be an attorney or someone well-versed in canon law that's always going to be in that board of inquiry. And so we've provided this additional note that the archbishop may appoint a legal advisor to the board of inquiry to help them. And that legal advisor will help them work through the canons, through legal questions, will not have a vote, but is there as a legal advisor. Now, moving on to the next section under Title IV, Canon 4, concerning the process of inquiry. Here's again a sort of a due process concern. How soon do we disclose to the accused bishop the contents of the approved presentment? So we added this phrase, if the board of inquiry does so determine to put the accused to trial, it shall immediately disclose to the accused bishop the contents of the approved presentment. And that moves us on, of course, to Section 6, which we had to change. And Section 6 now reads that if in the judgment of 2/3 of the Board of Inquiry there is probable cause to present the accused bishop for trial for violation of Canon 2 of this title, it shall, and then sub A, cause to be amended if necessary the presentment to reflect its findings. And that's just taking note of the fact that the Board of Inquiry may be presented with 5 charges against a bishop, hypothetically, and say, well, 4 of the 5 we agree on, but not on number 3. And so the presentment has to be corrected to reflect that. The Board of Inquiry doesn't actually change that presentment, but it causes to be amended the presentment to reflect its findings, and B, promptly transmit the approved presentment to the court for the trial of a bishop. Upon notice that the court for the trial of a bishop has served the accused bishop with the approved presentment, the Board of Inquiry shall make a public declaration that there is probable cause to present the accused bishop for trial. And you see, this is honoring the rules of procedure that have been approved at all levels of our provincial trial courts in terms of process and serving the accused. And make sure that the final public declaration by the Board of Inquiry follows the appropriate processes under the rules of court for each of our trial courts. Now, finally, we did a little bit of editing, again, kind of an old piece of business under Title IV, Canon 9 of inhibitions. It used to read that by unanimous vote of a panel. Now it was amended in other sections to read with the written consent of 4 of the 5 senior active diocesan members of the college by date of admission. There were 2 places in Title IV, Canon 9 where we hadn't made those changes yet. And that was just some negligence on our part, and so we're cleaning this up. So we're removing that by unanimous vote of a panel language and conforming it to what we decided upon in 2022 with the written consent of 4 of the 5 senior active diocesan members of the College of Bishops by date of admission. And that's in Title 4, Canon 9, Section 3, and concerning the inhibition of a bishop, and in Section 4 concerning the inhibition of the archbishop. Now, those are the proposed amendments that we have at this point. And again, getting back to that big canon that we're going to present under Title I, Canon 5 of Diocese on how we handle accusations, how we respond to them. We will present that based on your comments and others at Provincial Council 2023. The other ones that I've just presented to you are for vote by the church, by Provincial Council for approval or not, and ultimate ratification at Provincial Assembly 2024. Here's the process. You have until March 31 to send your comments, your questions, your requests to me, and there's my email at the bottom of your screen, pashy@americananglican.org. And upon receipt of your questions, comments, suggestions, I will send you acknowledgement of that, and I'm going to forward it to a subcommittee that will be working on that very area. And we're going to take all of these questions, comments, and suggestions very seriously, as we have every year. On March 31, we end that time for the whole church to make its comments. And for 2 weeks, until somewhere between April 15 and 17, our Governance Task Force will be amending these proposed canons changes. And then we'll submit a second draft, and that will go to all diocesan chancellors, to members of the Anglican Legal Society, and any delegates we know of, and bishops who will be going to Provincial Council 2023. And there'll be a second opportunity, probably until the end of April, in order to make those comments to the Governance Task Force. We will then revise that title, that draft version 2, and then on May 1, on or about May 1 or middle of May, at least 2 or 3 weeks prior to Provincial Council, we will send the final report out to all of the delegates of Provincial Council, so they'll be ready. So again, if you have any questions, please, or comments, please send them to me at that email address below. We'll put a copy of this report, this draft version 1 report, on our website, and I'm sure the province will on the ACNA website for you to look at. But please prayerfully consider how we can improve what we're doing. And if you like what we're doing, please feel free to let us know too. God bless you, and thank you from the Governance Task Force of the Anglican Church in North America and the American Anglican Council.